presiding. The light is not. Oh. No, I just can't. While court is in session, there will be no eating, sleeping, talking, gum chewing, arms resting on benches, and if you have a cell phone, please don't use it. Thank you. Good morning.
Thank you.
Have
This is case number 240943. This is Arthur Jenkins versus Ashley Johnson. The matter it's adjourned from a couple of days ago regarding a subpoena that was issued in this matter. Do I have Arthur Johnson? Do I have Ashley Johnson on the Zoom?
Yes.
All right, thank you, Ms. Johnson. And Ms. Johnson, you were telling me that you had some difficulties in regard to Mr. Jenkins, and you said there's something about a warrant for him or something. What were you telling me? Go ahead and talk to me, ma'am.
Yeah, so I don't know. That may be the reason why he's not here, because he was just charged with assault battery 3 times. And also, I filled out for appeal, but I never got a chance to appeal the case. The only thing I got in the mail was the subpoena, and that was it.
All right. Let's see what happened here. I'm taking a look right now. Yeah, the appeal was set up, and on the date that it was set for hearing, you did not appear. Therefore, the appeal was denied. So that's what happened there.
I was told I would receive something in the mail with an appeal date. I never got that. I went downtown for appeal. I never got a date.
Okay. Well, the notifications that I have in the file indicates that you would have received that date prior to the hearing. Be that as it may, the fact of the matter is that on the appeal date that was set for hearing, I don't have where you appear. That's the latest that I have regarding this file. That's the reason why the defendant is seeking to, right, that the plaintiff is seeking to enforce the judgment, because the appeal was denied because of the hearing date did not appear. Now, you always have the right to file motions in regard to that if you wish to do so. But I'm giving you the reason why. The appeal was denied, because it was set for, the file was set for December 5th, 2024. And when you did not appear, that's when the appeal was denied. If you believe that something went wrong there, then you file your appropriate motions and so on and so forth.
You said I could file a motion?
Yeah. The notice to appear, in this matter looks like, I'm looking, this is somebody else's work. It's like the notice to appear went out on the 30th of September. That's when the notice was sent to the address on Fairport Street on the 30th of September, and set the hearing date for the 5th of December. When no one appeared on the 5th of December, the appeal was denied. That's the history that's in the court's diary. All right, so the judgment remains in place, and that's where Mr. Jenkins is attempting to collect the balance or the amount that was entered with regard to the judgment. He did not appear on the subpoena a couple of days ago, or he did not appear to move forward with regard to the subpoena in this matter. So what I'm going to do, ma'am, is I'm going to simply dismiss the subpoena. If he wishes to refile, he certainly can do so. And if he files to enforce the subpoena, or he files a new subpoena, then you would just have to return the court once you receive the notice on the new subpoena. That's as much as I can tell you about the history of the file. That's what the records show. So I'm going to simply dismiss the subpoena. So at this point, there still is a judgment, but the subpoena to collect on it or to get information from you, I've dismissed that. And that can be refiled, but at this point, it's dismissed. All right. I wish you well, ma'am. Good day to you.
Okay.
All right, the court calls case number 22-185, 191. This is River Place Apartments versus Jacob Myers II. The matter is before the court. I have a set for review.
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
Thank you, counsel. Good morning to you. Do I have Jacob Myers on this zone?
Good morning, Your Honor. Jacob Myers is here.
All right, thank you, Mr. Myers. Good morning to you. I received a document entitled Objection to Motion regarding this matter. It looks like the status of this case is that there is, while the court previously issued an order allowing for installment payments in this matter. That looks like the latest that I see. I do know that there was a motion to set aside that order. But again, the order was issued on the 20th of February 2025. So let me hear what your objection is, Mr. Well, hold on a second. Let me go to counsel. Counsel, update me on regarding this matter, sir.
Your Honor, back when the installment payment order was entered, the court had set it for a review today. Just to review Mr. Myers, whether there's any change in Mr. Myers' income that might merit an increased payment. There were a couple of missed payments or late payments that led to our office seeking reinstatement of the garnishment. But since that time, first of all, I think the court actually denied that on an ex parte basis. And since that time, Mr. Myers has brought his payments current. So at this time, we don't have any objection to the installment payment order continuing. I think the court just wanted to, at the time that the order was granted, come back and reevaluate Mr. Myers' income.
Right. That was because the judgment in this matter was so high.
Correct.
Yeah.
So,
all right, Your Honor.
Yes, sir.
Yeah, this installment plan was actually set the 6th of November 2024.
Yes.
And the missed payments that he's referring to was a miscommunication between the office there at River Place and between myself, because they started to garnish even though we had this payment plan in. And when it came down to it, once the judgment went in, they said they would send the checks that they garnished for it back. I told them to keep them for payments for the coming months. They said okay, and then maybe a month or so later in December, I received something in the mail saying that they were trying to set it aside, saying that I didn't make a payment. I called them. It was the holidays. When I finally got in touch with them, they were saying that one of the payments they were entitled to keep because of the date on the check, and they had called up to my job's payroll and found out that they were entitled to that check. So upon me receiving the mail saying that they wanted to set aside, I put a motion in saying, it was just, like I said, a miscommunication, because nobody ever called me and said they were going to keep one of those checks for garnishment instead of adding them to, my monthly charges that I told them to add them to the last time I spoke with that office. So you set it aside, but then right after you set it aside, they took a payment from me to continue the payments, and then they garnished me that following Friday. I paid the payment on Wednesday after you said I could go ahead and keep going with the payment plan. Then they garnished me that Friday, and then they garnished me the next Friday after that. So since then, I've been tumbling down in finances. So I got a hold of your court clerk, and she said they weren't supposed to be garnishing me at all. I talked to their office. The garnishment department said that they knew that they weren't supposed to be garnishing me, so they don't know why collections was still taking it. So the court clerk said that I wouldn't have to pay February's, because the second time that they garnished me was the day before the payment was due for February's payment. So she said I wouldn't pay that one. I made the payment in March, and I continued to pay. But at this time, I just would like the court to just go over this, because I mean, it just seems like they can, say, okay, we're in a payment plan, but I want to garnish you. They've done this twice at this point. And at this point, I'm actually on disability. I was involved in an accident on the 23rd of March, which left my fibia and my tibia and my right leg broken. So I'm on disability for 3 months. I just would ask the court to show leniency, because at this point, I just feel like that the River Place and their garnish department has played with the court and myself, with knowing that you set the order to continue with the payment plan, and then they just went ahead and still garnished me for weeks at that point after that.
All right. You have a really long recitation. I have a very simple question. My question is, are you
Okay.
overpaid? Are you overpaid, or are you under for the
You,
for the amounts that were due under the installment order?
you said, have I overpaid?
Yeah, are you overpaid, or are you underpaid?
Well, where I overpaid, originally where I overpaid, they like I said, I spoke with them and told them that they can keep those checks to go towards the coming months for the payment.
I want you to, I turned you off because I want you to assume something that's good to assume. You told me something already. I heard that. You don't have to tell me that again. My question is very simple. The question is, are you even now? I guess I should have made it even that simple, because if you're even now, then you're even now, and the order that is in place is the order that's in place. If you were garnished, and I believe that you were, the order was set aside at some point and then reinstated. Sometimes in that lapse, it causes interesting kind of problems, and I don't think that any of that was your fault. The question becomes now, rather than this going on and on and on, is whether or not you're up to date on your payments, or whether or not you have overpaid, and there are a few payments that you don't have to make because you're ahead of the game. Where are we today? It sounds like today everybody is even. You tell me if that's not true, and we figure out a way to make that adjustment. That's what I want to know. Let me hear from counsel, and then I'm coming right back to you, Mr. Myers. Answer that basic question for you, Mr. Myers, sir. Counsel.
Thank you, Judge. I believe we're even. There was a voluntary credit card payment received on April 25th in the amount of $250. A voluntary credit card payment in the amount of $250 received on March 26th. No payment in February, and that goes back to the recitation that Mr. Myers just put on the record. A voluntary credit card payment of $300 on January 29th. Two garnishment checks were received in the month of December, each in the amount of $164.07. And prior to that, the garnishment was still in effect.
All those been applied and credited. The garnishment.
Everything's been applied and credited, and Mr. Myers still has a balance on his account, Your Honor, of $11,040.83.
All right, Mr. Myers, I think that's information I needed. Tell me if that's not where things are, whether the parties are up to date on the payments, because I have the payment order that's in place. There shouldn't be any more garnishments. The payment orders in place. There were some, obviously, over time, but that has made everything even up to now, at least from what I'm hearing. Tell me if there's something else I need to hear in that regard, sir. Mr. Myers, you have to unmute yourself. *6 will do it.
Okay, yeah, we are up to date, and I just want to clarify, the order was never set aside. They still.
Let me stop. I don't, I let you talk for about 5 or 6 minutes, and I got a bunch of cases. I don't care if it was overturned or not overturned or whatever. The question now is whether the parties are even. That's a basic question. Now you want to talk on and on and on, then file another motion. We'll set another hearing for another day. But this is going around and around in circles about nothing. Now it seems like there was something else you want to tell me that's relevant. We assume that everybody's even today. What do you want to tell me going forward? I guess that's my next question, because I don't want to go back and back and back and over again. What do you want to tell me, Mr. Myers?
Okay, we are even, sir. Going forward, I am on disability now. I only receive 58% of my pay right now. I'm off for 3 months. I have a return date of July 1st. So I was I'm sorry.
What do you have, in light of that, what do you ask me to do? Because you have an installment order at $250 a month, so talk to me.
Yeah, I mean, I would ask the court lower it to 200 because at this point, um I might need to file another motion, like I said, to explain the situation that I'm in because of, the previous garnishings. But
Yeah, Dom, you found motion, you're not gonna explain anything to me. I'm not even gonna listen to that because
wow.
you told me what you want to tell me already. You told me everything you wanted to tell me. What you want to do is you want to go back and forth and back and forth. You told me that they garnished. Oh, now you want to interrupt me? You told me they garnished you when they shouldn't have garnished you. You told me you were paying under the other plan. Then you told me that you didn't have to make payments because they garnished your money. They took your money. The bottom line is that comes to, are you paid up now? You told me yes. The other side says yes, you're paid up. Now you're asking me going into the future that you want to pay $200 for a period of time because of some disability issues that you have, which are very important considerations. What else you want to talk about now?
That's it, sir.
Yeah, I mean, I'm not trying to give you a hard time, but you will note that, of course, I have several other files, and this is going on for like 15 to 20 minutes now when the parties are in agreement that the payments are up to date. Okay, the gentleman wants to make $200 payments over the next 3 months. I think that that's a reasonable thing. He says he's on disability. I'll review it at the end of that period. But I'm inclined to reduce it to the $200 that is requested for that 90-day period, and then it will revert back to the 250. If he believes that it should not revert back, or that he has ongoing problems, then he would have to file a motion to ask the court to lower it then. So I'll lower it for next. No, you shouldn't be saying anything. This is my ruling that I make. I will lower it for the next 3 months, and then it will revert back to the 250. And again, anytime anyone has a problem such that they believe that they should file a motion concerning something that they would like the court to adjust, you can do that. Don't file a motion and just talk to me about something. Don't do that. For example, if there's a situation where Mr. Myers hits the lottery and comes up with $2 million, counsel would file a motion to say, Judge, you should have to pay it out of that $2 million or whatever. That you wouldn't even need a motion, but that would be an appropriate place to file a motion. If Mr. Myers ends up flat on his back, then somebody would need to file a motion to say the installment should be reduced because I'm not making any money right now. So those are the kind of things that you file a motion. I'm always willing to hear that stuff. And I'm always willing to hear the history of the case where there were problems, because obviously with the court entering its order and it is subsequently setting a new order because contrary to something stated here, the previous order was set aside and then it was reinstated. I did that because the information I received from the plaintiff in this matter indicated that payments were not being made. Then when I saw that the payments were being made, I corrected that. That's why I have an installment order dated 2/20/25 for the $250. So be that as it may, the point is that the parties had some confusion along the way that resulted in money being taken through one channel that it shouldn't have been taken through. And so the big challenge here today was to find out whether or not there had been overpayments, because obviously if there were overpayments now, then the defendant, Mr. Myers, would not have to pay going into the future until those overpayments are exhausted. And that's really the only question that needed to be answered today. And then the second thing was that Mr. Myers is asking for a temporary reduction. He has convinced me that there is a sufficient basis for doing so. So I will reduce the payment. The payment will be $200, and that will be, I believe you said the month of May is already paid, correct?
No, Your Honor, the month of April was paid. I believe he's making his payments on the 20th, on or about the 25th of each month. So that would be the May 25th payment, June and July.
Right, that's what I was getting at. All right, so Mr. Myers, May, June, and July payment is reduced to $200. In August, it would revert back to $250. Of course, anybody can file a motion at any time if there's other information that needs to be brought before the board. So the petition for reduction at this point is granted as set forth by the court. I do wish both sides well, and good day to both of you.
Thank you, Your Honor. Have a good
Thank
day.
you, Judge.
All right, the court calls case number 24-160313. This is Hadley Towing LLC versus Gregory Bagley. The matter is before the court regarding an adjourned status conference date. All right, your appearance for Hadley's Towing LLC.
Yes, good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
All right, thank you, sir. Thank you for your patience in this regard. I'm looking for Gregory Bagley. Mr. Bagley, if you're there, say something at this time, please. Mr. Bagley. All right. I know I reset this for hearing on a previous occasion. I don't see Mr. Bagley here now. Counsel, any updates at this time, sir?
No, we've not heard from the defendant, Your Honor. I do note that it was reset. There may have been an issue with regards to proper notice on the original date set, but we've not heard from Mr. Bagley, and frankly, we don't think he's raised a valid defense in his answer, and we'd move for the entry of a default judgment this morning.
All right, given the defendant's failure to appear in regard to this matter, and I would indicate that the new notice was sent out on the 2nd of April, setting today's date at certainly sufficient time, and the notice was directed to the address provided by Mr. Bagley on his answer on Pennington Street in Detroit. The defendant has failed to appear. Default will enter at this time, and judgment may be granted on that default pursuant to the court. So ordered at this time.
Judge, how does the court want us just to mail that in, email it in, or do it under the 7-day rule?
Well, what I'm noticing here, just one second. You have submitted an application for default that was submitted in January. I believe I received an answer subsequent to that date, and so the default did not enter because of that. Because of that intervening answer. I am now signing the default application in this matter based on the failure to appear. And so you can go ahead and submit the judgment. A copy of this will be sent back and then you can submit the judgment in this regard. Now you have a default and you have a judgment connected to it, and I'm not sure if I can direct both of them at this time. So I'm clearly going to enter the default today. Then I would suggest perhaps that you send the default judgment, maybe under the 7-day rule, some type of notice.
Very good. We'll submit the judgment under 7-day rule, Judge.
All right. Thank you, Counsel.
Thank you, Judge. Have a good day.
All right, this is case number 24-167-629. This is Midland Credit Management Incorporated versus Toy Roll. The matter is before the court on the filing of a motion for summary disposition. I believe I have that set on for hearing on today's date. Your appearance for Midland, please.
Your Honor, Violet Oscar on behalf of Midland Credit Management, P84802.
All right, thank you, Counsel. Good morning to you. I'm looking now for Ms. Toy Globe. Good morning to you. Ms. Globe, are you there?
She is on mute.
And Ms. Globe, if you, I've sent you a notice to come off mute. You can hit *6, that'll get you off.
Okay, I got it. I'm sorry about that.
Not a problem. Good morning to you, Ms. Cole.
Good morning, how are you?
I'm good. I'm good. All right, so there's a motion that's been filed where the plaintiff is saying that on this debt, there's no genuine issue of material fact and that there hasn't really been a defense raised to this issue. I don't see where there's a written response to that motion. So let me hear, Madam Counsel, then I'm coming to you, Ms. Glow. Counsel?
Yes, Your Honor. We decided on behalf of the plaintiff to voluntarily dismiss this particular case. And I had the opportunity to speak with a defendant in a breakout room, and we would like to stipulate to a dismissal.
Right. And this, Ms. Glow, that's your understanding as well, that the matter will be dismissed at this time. Is that correct?
Yes.
All right. All right, so I am noting that on the file now, and the matter will be dismissed. Counsel, you said that was a dismissal with prejudice or without prejudice? What did you say?
That would be with prejudice.
All right. The court will sign an order of dismissal with prejudice regarding this matter, and I wish the parties well. Good day.
Thank you,
All right.
you as well.
Thank you, Your Honor.
Thank you.
We have full.
No.
How the hell? How do you leave these meetings?
All right, this is case number 25142994, American Lending and Financial LLC versus Levita Marquise Lewis. The matter is before the court. Looks like I've got this set on for an adjourned status conference. All right. Your appearance for the plaintiff regarding this matter, please.
Good morning, Your Honor. Robert Zielinski on behalf of plaintiff P69250.
All right, thank you, Mr. Zielinski, and good morning to you. I'm looking now for Levita Marquise Lewis. Thanks, sir.
Let's say Lewis.
All right, thank you, Mr. Lewis, and I got it now, Levente. All right, good morning to you, sir. All right, so let's see. This is, of course, here regarding the filing of it looks like a deficiency complaint, where it looks like there was a recall on a car, and then ultimately the car was sold, and then there was a deficiency balance, that kind of thing. The defendant is in the courtroom. Have the parties talked about this matter in terms of trying to resolve it in any way? Let me talk to counsel and then I'll come to you. Counsel?
We have not, Your Honor.
All right. And then I say application for default. So what's going on from your perspective here, Mr. Lewis?
I had to get a car to get back to work. I got laid off. I told him I couldn't make many more payments. I tried to get some lower. The car place I bought the car from was shut down. So I called the finance people. They told me they couldn't do anything about it. So I took stuff for the car. And I couldn't pay for it. So I took the car back myself. Paid the car all the way up. I ain't holding nothing. Car went to the car back.
Yeah, I'm sure they sold it at an auction.
They sold it for $2,500. And I'm stuck with the rest of it.
So defendant was giving a recitation of what happened. I think the parties are on the same page regarding what happened. The complaint says something about $8,000, but then the file registers a claim of 4,000 and something. What is the claim in this matter?
Well, I have, the complaint should be for, the deficiency is, $8,456.60. Where are you getting that 4,000 figure from, Judge?
The register of action says for $4,322.98. I do see we complain in this matter indicating quite a different, and now I see why. Because the register of action that's contained within the file does not belong to the spouse. So now the spouse. You pull that out. And, well, you know, obviously it's an unfortunate situation. Even when you run into a situation where you can't pay the debt, turn the car back in, and it's 6 in one hand, half dozen the other. Not a whole lot that you do, and the paper becomes the debt. And in our society, in many ways, people end up in a hardship like that. They consider bankruptcy and things like that, or you end up having to find a way to get the debt without that.
I am my mother provider. I can do like 100 a month right now. I'm unemployed. I don't have no job. That's not agreement.
So the first step is resolving the judgment itself. So what that would mean is that if you do not disagree, if based upon the circumstances, you owe the 8,400, whatever the court cost is, then what would happen is that the parties would have to kind of agree that that's what's owed. You agree with that? I mean, and the only reason I'm talking to you in this way is that I don't see a defense.
I couldn't even get a lower car or nothing. I couldn't even take the car back and get a lower.
And you understand why some things that I don't even like, and that is that whatever the contract is between the parties, that's what the parties have, have a right to enforce whatever the contract is between the parties. And the car sales industry and how with the statutes of the state of Michigan allow in that regard, it is, and I think it's that way around in many places in the country. But I know how it works in Michigan, and it's tough. If you sign up for a debt and then you're unable to pay it, you lose a job, sick. Yeah, so if there was something else I could tell you about that, I would. There's nothing else I can tell you about it. That's where those things are. So, counsel, it sounds like there's not disagreement on the debt. The defendant wants to start attacking it. He said he could start paying the debt at $100 a month. He obviously believes that the parties, at least he's kind of indicating to me, he believes that the parties should, he'd like to see there be some room for negotiation because he said he turned in a good car. They probably auctioned it. They could have got more value. So he's kind of saying it. I'm articulating it a little bit better. He's saying that he believes that the auction is not a reasonable auction. It could have gone before. We know the rules is whatever it goes for, whatever it goes for. So basically what he's saying is that he should get something off of that $8,000 something, and then he's going to enter into a judgment. Whatever the balance is, pay $100. Your thoughts
are? Yeah, I'm happy to talk to him about that. There's several possibilities. I have with room. So if he wants to call me after this hearing, I don't know. I guess I'm thinking, Judge. I can't agree to something on the spot, but I can talk to him, and probably it sounds like we can come to a resolution and get something down there to close the case out. So I don't know if you could do your standard scheduling order, and we can make sure he has my number and call me.
Yeah, this is as strange as it may seem today. It would have been better if you came on Zoom instead of in the courtroom, because then I could have. That's no problem. But I could have put you in a breakout room where the two of you could talk. So what I'm gonna do is I'm gonna put it over for, simply for 30 days, council. And I wanna give him information to reach out, to contact you. What you're talking about is how can you get some of that shaved off? You wanna reach a negotiated outcome. And if you can resolve it, you pay $100 a month. That could be revisited.
Until I start working.
And then you start working, and you set a higher amount, so you may be able to get it worked out. So Mr. Lozinski, Zelinsky, I'm sorry. What is the best place for him to reach out to you? Is that I have the number at Mr. Katz's office, or did you have a number you wanted to give us now, so that I can make sure that
it's that number 248702 number.
Okay, and I'll make sure that Mr. Katz, I'll make sure that Mr. Lewis has that 248 number, and then he's to reach out to you, Robert Zelinsky, and talk about it based upon what was discussed here. And I'm going to give you a date about 30 days from now. My clerk's going to pick that date in just a moment. Then you come back into the Zoom. If you got it all worked out, then Mr. Zelinsky will simply submit the paperwork, and you won't have to come back to that date. But the date will be an opportunity for parties to come back if they have to. Okay. All right. So, Madam Clerk,
June 10th?
yeah, June 5th is fine.
June 10th.
I'm sorry.
June 10th.
Can you keep it at the 5th? 4?
Oh, no, yes.
A lot of stuff.
Yes.
All right.
The 4th is fine, good.
Okay, 4. All right. So the 4th, at 9:45. 6/4, 9:45. That's when you come back to court, or in the Zoom, whichever way you want to do it. And if you get it all worked out, then you have paperwork to send. I'm gonna write that number down. Again, I know it's on some of your paperwork. I'm gonna write it down so that you call Mr. Zelinsky and try to talk with this. All right, I wish you the best, sir. Thank you. Thank you, Mr. Zelinsky. Good day to you, sir.
To confirm, that was June 4th at 9:45?
That's correct, sir.
Okay, thank you.
Got a different number. I would go call.
Yeah, that's the number. Just so. Oh, it's not. Yeah. Yeah, it's on that form. Okay, that's the number you call Mr.
Thank you, Your Honor.
Zelinsky.
Thank you, so.
Good day to you. Yeah, this is.
Okay.
All right, the court now calls case number 24-154217. This is Hassan Al-Hassan versus Joma Neg. The parties are to appear before me for review. This is a matter that involved parties reaching a resolution for repairs to property. And they were to appear for review on today's date. They have not appeared in regard to this matter. So that part, on this matter, let's set it for one more. Let's set it for one more day, maybe on the 4th.
Okay.
And for review. Hopefully, the parties are achieving the success that they indicated.
Okay.
This is the file for that case. So maybe that register of action that I told you was in the wrong file, maybe it's in the right file. Because this is the American versus Marquis file.
Oh, okay, all right.
Okay. So we'll why did I have that one? Let me see that.
Well, American versus Marquis,
Yeah.
his is 994, so this is 570.
Is that mixed up?
Yeah, this is wrong. I don't know why. That's wrong.
No, that register of action you pulled out of there or whatever, should go in on Keith's file, you see what I'm saying?
Yeah. Oh, 994, I think you could, yeah.
So let me have that file back. Why do I have that?
This one is 570.
Is
You
that
shouldn't
all?
have this out at all.
Okay, that should be in front of me?
No.
Okay, got it. Thank you. This is case number, case number 24241280. This is Gabria Goodell versus J. Taylor and Associates. The matter is before the court on an appeal from a determination of a magistrate. The record should reflect that the court.
Hi, good morning.
Just one moment, ma'am. The record should reflect that on the 26th of February, the court on the petition of the plaintiff in this matter set aside a dismissal of the appeal and set the matter on for hearing on today's date. All right, so I'm looking for Gabria Goodell. You on the Zoom, please say something at this time.
Yes, it's great, Brianna. Just call me. You can call me Bree for short.
I can't do that in court. I call you Ms. Goodell. Thank you. I'm looking for J. Taylor and Associates. J. Taylor and Associates. Just one moment, man. Further files. All right, so all right. So a judgment was entered in this case in December of 2024. All right, so ma'am, why are you appealing this? What's going on here?
So I'm appealing it because a judgment was given them to reward me or give me my funds back. And Jay Taylor was not willing to give me my funds back, so he sent an appeal. And so the appeal is the one where I was in the wrong hearing and it was dismissed.
Well, the dismissal has been set aside. So you already have a judgment in this case. So the judgment is still good.
Okay, so what do I do moving forward, knowing that they are essentially trying to deny access to paying me my funds back? Do I get a subpoena or what? Because that was also the part as well in the case. What are the next steps that I need to take moving forward to make sure that this is not dismissed and that I can get access to my funds?
Well, you have what you're trying to do is get legal advice from me as to what to do, and I can't give you legal advice. Now, here's what, from a practical standpoint, I think that you stated what you need to do. Once a judgment is entered, this is information, it's not legal advice. Once a judgment is entered, the defendant has 21 days to pay it. If they don't pay it after 21 days, and of course that time is already passed, you have the right to file a subpoena to try and find information that allows you to seek to get your money. So what you do with the subpoena is you get them to come forward, or they have to disclose certain stuff like business identification number, addresses, bank accounts, things along those lines. So all of this stuff about a claim of appeal, you really didn't need any of that. You need to file a subpoena and fill out a subpoena form and submit it to the court. I will sign that, and then that subpoena will have a hearing date. Make sure that when you list on that subpoena, list all of the information you want them to bring.
Can you say that again? I'm sorry. You said list all of the information. What exactly?
On the subpoena form, you want to list the information that you want J. Taylor and Associates to bring to the hearing. So I'm sure you're going to want like a business identification number, corporate records of the corporation. You want any identifying information for Mr. Taylor, you want bank account numbers, any social security numbers, that's the kind of stuff that you want us to do. And you get that form filled out, you file it with the court, I will sign it. Then you have to have someone to serve it on J. Taylor and Associates, and they will be required to appear at the hearing and to bring that information. If they don't appear, what will happen is then the court will set up a show cause. The show cause hearing will demand that they appear at a particular hearing. If they don't appear for the show cause, then the court will issue a bench warrant. Is where you want to go if they're not paying you money. Bench warrant then turned over to the county sheriff. And the county sheriff will make contact with the persons there at J. Taylor, and they will either arrest them or collect money from them. So there are steps involved that you have to follow. The first step is to issue a subpoena for information.
Okay.
Right. Get that filled out. Subpoena form, get it filled out and submit it to the court. I will sign it, and then you'll need to get a process server to serve it on somebody at J. Taylor Associates.
Okay.
And then and the hearing date will already be in that subpoena form. Once it's sent to me, I will set a date. I will sign. All right.
Okay. Sounds good. Thank you.
All right. I wish you well, ma'am. Good day to you.
You too. Bye-bye.